Hi guys, it's Kathy. I hope you're doing well. Happy Friday. Made it to Friday. We are on day 2 of this, and I think I didn't watch the whole thing, so I don't quite understand. It looks to me like they have the prosecutor on the stand, which I know is ridiculous to even say. So, I don't know what's going on, but that's what I saw. So, we'll figure it out together. Here we go.
Alone. And I would appreciate the court allowing us to use that if that's all we're going to get to use.
So, they're talking about transcripts, putting transcripts in. So if you missed what happened yesterday, if you're just tuning in today, down in southeastern Georgia, one truck got stuck in the mud. Another truck came and got stuck in the mud. And then another truck came while there was a bunch of people around these trucks, figuring out how to get these trucks out of the mud, which is a normal thing down there, I think. So it's not like, that's like a normal thing. You get stuck in the mud. So the hunter gets out of the truck, the third truck to come on the scene, and he gets into a fight with the driver of one of the trucks that are stuck in the mud, the one that was stuck in the ditch. And then there was one gunshot. And then the man who was driving the second truck, who was inside the truck at the time, Hunter was outside the truck, Mason was inside the truck. Mason died, all right? He got shot in the head with that one gunshot, and he died. So Hunter, the guy who came in the third truck, he's on trial now, okay? I didn't tell you yesterday, this is new. He has 3 counts right now. I know the first count is murder. The second count is aggravated assault. And I think the third count is also murder. I don't know how they can charge him with 2 murders. I don't know. I'm not a lawyer. And never will be. I also don't know how. It looks like the prosecutor is on the stand right now. I don't know how that's possible either. But that's where we're at. All right?
But I would submit to the court that due to the fact that this is about the door being open, as I said, that you should be allowed to open the door.
How far are you going, Mr. Pittman?
Your Honor, I'm not. Matter of fact, I would rephrase my question on the thing if
And your question then would be?
Mr. Haynes?
Bobby, did you know my middle name is Rose? You said, hi, Kathy Rose, beautifully. Hi, B.I. My middle name is Rose. It's like I'm in trouble. You called me by my first and middle name. What did I do? I'm in trouble.
If your 3 prior interviews with this witness were not sufficient for you to do a murder charge, don't you think you should have interviewed or not relied on Officer Howard that interviewed this witness in person yourself in detail before you jump to a major decision?
I did.
Hold on a minute.
I didn't know.
I wanted to understand the question. You got an objection to that? Huh?
Yes, sir. It's still same scenario. Where it gets into talking about all the different prior interviews and such, and that opens the door to that, I believe. And you got this whole situation. It looks like we're trying to hide something from them. And the jury, as far as withdrawing the question at this point, that's like unring a bell. Heck, they know we're in here talking for the last 30 minutes about this business. That there's some major issues that come up in this trial, and you can't unring, whether or not you tell somebody to disregard something, you can't unring a bell in these situations. Of course, it's been a trial long enough to know that. And so the damage is done, and the door has been opened, and that's my position.
Your Honor, and he opened the door. He said, I have talked to this witness 3 prior, interviewed this witness 3 prior times.
He said that in response to a previous question.
He said that in response whenever I asked about why he didn't do it and why he did not interview the witnesses himself. He said, I interviewed this witness 3 prior times. That was his response to my question. And I didn't ask about what they said or anything like that. He volunteered, he had interviewed the witness 3 times. My next question was, well, if it changed your mind from involuntary to a murder charge, then don't you think it would have been important to interview this witness personally in detail? That's it.
All right. We'll stand in recess for a few minutes.
Your Honor, if we can, address one other thing that Mr. Pritchard said. I understand that he asked this witness whether or not she was going to vote for privilege yesterday. And my understanding was she said that she wasn't sure. I think that what he's going to have to do is call her to stand outside the presence of the jury and ask her if she intended to vote for privilege and if she would testify.
Now, I'll state my place.
Yeah.
I'll state my place in Austin court. The specific conversation I had with her was, is she going to do it in the state's case? Is she willing to testify in the state side of the case? I will not testify in your side of the case. She's going to invoke that privilege. And she told me that the only way she would be testifying in this case is if she were to testify on her husband's behalf.
And I'll state in my place as an officer of the court that she said that she told me she didn't know whether she would testify or not for the state, but then I think she will. I mean, but now I think Mr. Pritchard needs to be clear on that.
Okay. We'll stand in recess.
It's not your fault, Linus. Once I start babbling, it's normal for everybody to just check out for a bit till I'm done. So I wrap it up.
Everybody can be seated. Thank you. Is Miss Kersey present now?
She's out in the hallway, I believe, Your Honor.
All right. I think at this juncture, we'll ask Special Agent Hayes or DEA Agent Hayes now to step down.
Yes, Your Honor.
And I'm going to bring Miss Coursey in. Kersey. And we're going to determine whether or not she's going to invoke her privilege. Any
Yes.
objection from the state in that?
No, Your Honor.
Nothing but the defendant.
All right. All right. I need Miss Kersey.
All right, Miss Kersey is the wife of the alleged murderer.
I'll place her under oath solely for the purpose of asking her about whether she's going to invoke the privilege. Okay?
Yeah.
Miss Kersey, if you'll come up here for me, please. If you'll raise your right hand for me, please. Do you solemnly swear or affirm that the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God?
Yes, sir.
If you'd be kind enough to state your name for the record and then for the benefit of the court reporter, if you'll spell it.
Caitlin Michelle Kersey.
Thank you. You can be seated. Ms. Kersey, it's come to the court's attention that, well, let me just say it this way. there's an issue that has arisen.
Doesn't this judge just make you feel good? Just him talking. It doesn't matter what he's saying. I love this judge.
In this matter as to whether or not you are going to invoke your right to what the law recognizes as a spousal immunity, or a spousal, what's the correct word?
Privilege, Your Honor.
Privilege, excuse me. And do you understand what that privilege is?
Yes, sir.
And what is your understanding of that privilege?
That I have the right not to.
You have the right not to what? Testify as to what?
Against Hunter.
Huh?
Against Hunter.
All right. Is it your intent to invoke the spousal privilege in this matter?
I would always invoke it. If you were married to me, I would never testify against you unless the crime was against me or my children. If it was my children, not only would I testify against you, I would have an army of people willing to get up there and say exactly what I want them to say.
I'm not giving up my right.
Ma'am,
I'm not giving up my right.
you're not giving up your rights.
That's
You're
right.
not giving up your right, meaning that you're invoking your privilege.
No, I'm not revoking it.
All right. Let me make sure. You are invoking the spousal privilege in this case, meaning that you will not testify against your husband, Hunter Kersey.
Correct.
Solely as to that issue, does the state have any question?
No, Your Honor.
I do.
Okay.
Ms. Persia, my understanding of the marital privilege is that you can elect not to testify, period, okay? It's not asking what your testimony is,
Yes, sir.
okay?
That's not what my husband told me marital privilege was when I was 24, sir.
Will you testify as a witness in this case?
Yes.
Okay. So, with that said, does that mean that you are not invoking your marital privilege?
I'm not getting what y'all are asking me.
Pardon?
I'm not getting what y'all are asking me.
I'm sorry, I didn't understand her response.
I believe she said, I'm not getting what y'all are asking me, Your Honor.
All right. Let's just show it quick. Will you testify?
Yes.
And you anticipate testifying?
Yes.
All right. Thank you, ma'am. You can step down and go back out.
Brent, I'd marry you. I would marry you only if A, I can invoke at some point in my life marital privilege in a courtroom. That has to be a given. Like at some point, I have to get up there and say, no, I'm not testifying against him. A. And B, we just stay living in our separate countries.
All right. In light of Ms. Kersey's statement that she is not going to invoke the privilege,
That's what my understanding is.
is that your understanding, Mr. Pritchett?
She says she's going to testify, Your Honor.
All right. With that being said, then I'm going to allow Mr. Hayes to testify as to the entirety of any statements that were made to him by Ms. Kersey.
Thank you, Your Honor.
All right? I think counsel for the defense has opened the door for that to occur, and you can do that on your direct examination.
Okay, but wait a second, Judge. What happens if, right? What happens if she gets on the stand and she says, I'm not going to testify against my husband? I'll let you know what happened. I'm not testifying against my husband. What happens? Does she get held in contempt or what? I don't even know. I don't even know where he thought this was going to go. And I don't have every second of this court case. So I don't know if we're going to see it or not. I'm so upset. But don't worry, guys. This is the last trial you and I go through like this. I finished a whole system where I get the start and the beginning of every single docket I want. All the time. It's perfect. It works well. So this is the last time we'll have to deal with, I didn't get all of it.
Of course, you got the right to delve into it now without hesitation.
Okay, thank you.
All right, Mr. Hayes, let's bring the jury back in.
I hope the judge's back is feeling better today. I know Judge Reeves isn't going to be a judge anymore in November. I don't know about this guy, though. Oh my God, I can see the jury. Every time they show the jury in a trial, Jack gets so upset. Oh my God, we can see the jury. It would be a privilege to marry
Everybody
me.
be seated. Mr. Pittman, you may proceed with your question.
Thank you. Mr. Hayes, you said that you decided to charge, or Officer Hayes, excuse me, that you decided to charge Mr. Kersey with the offense of murder based upon an interview that was done by Eugene Howard.
Yes, sir, that is correct.
And I know that Mr. Howard was the one that did that interview, so he would have to testify to that. But you also testified that you have previously interviewed this witness 3 times.
Yes, sir, that is correct.
Okay. And each of those 3 previous interviews was not sufficient evidence yourself that you thought to justify a charge of murder.
No, sir, I did not.
So there was a change from the 3 previous interviews to the 4th interview.
Yes, sir, that is correct.
And the 4th interview is the one that you didn't do yourself.
Yes, sir, that is correct.
And do you not think that it was important, Officer Howard, if you're going to take...
Officer Haynes.
Hayes.
I mean, yes, I'm sorry, Officer Haynes, because I was thinking about Officer Howard, didn't if you think that it's important enough to take the leap to a murder charge, don't you think that it would have been necessary for you to interview this witness and determine why this story was changed?
No, sir.
No, sir?
No, sir.
So you're basing a murder charge on information that you did not collect yourself?
Yes, sir.
so you decided to dismiss the other charge and then go back and charge him with murder?
Yes, sir, that is correct.
It's been asked and answered multiple times at this point, and.
Let's go on to something else, Mr. Pittman.
No, I'm not tall. 159 centimeters isn't tall, right? Who are you talking about? I'm 5'2"3/4. That's very short, but it's okay. Maybe I converted wrong. I could have converted wrong.
You said that you had interviewed other witnesses as well. You take those statements into account on this?
Yes, sir, that is correct.
Now, those witnesses not testified.
I don't know if Billy and Jennifer have. I don't know if Billy and Jennifer Tidwell have, but a lot of my thinking was based off of their statements, but I don't know if they've testified or not.
Did you see, Jennifer Billy Tidwell did testify?
Yes, sir.
Right.
Okay.
And
You're telling him that. Because
Well,
I understand from what he's testifying, he doesn't have independent knowledge of that. Is that correct?
Yes, Your Honor, that's correct.
He doesn't know who's testified.
Okay.
So you want him to accept,
Not here. I'm sorry, Your Honor.
you want him to accept your statement that they have in fact testified.
Well, Your Honor, and I apologize because I forgot that he was not here yesterday morning whenever we got started and didn't hear those statements. Okay.
Yeah, he's been out under the rule of sequestration.
That's right.
Yeah.
I understand that.
Well, okay. Okay, I'll pass the witness.
All right, redirect.
Yes. Thank you, Your Honor. Now that we've had this time to use this issue, go through this issue, who is the witness that you're talking about made now 4 different statements, and the 4th one was the one that was so critical?
Caitlin Kersey,
And who is Caitlin Kersey to the defendant?
the wife of Hunter Kersey.
Okay, and what's your understanding of where she was during this incident?
She was seated in the passenger seat of the truck next to Hunter when this incident took place.
Okay. And you were asked to characterize, or excuse me, Mr. Pittman characterized that all her prior.
Yes, sir.
Sorry.
Need to get up to the mic.
Okay. Yeah, Mr. Pittman characterized that everything that she previously said in all 3 interviews with you were all corroborative of the defendant's statement that the jury's already heard. Would you find that to be a truth? Is that accurate, that they were all exactly the same?
No, the statements changed every time that I spoke to her, and that's why I sent another agent, a new face, to go speak to her while I was here.
Okay. What were the nature of the circumstances when you first talked? When did you first talk to Caitlin Kersey?
I first spoke to Caitlin Kersey the night of the incident prior to speaking with Hunter Kersey.
Okay. And of course, she'll be here to testify now at this point. That's my understanding. There was some question earlier, and that's
Just ask questions. Let's
Okay.
don't comment on anything other than that, Mr.
Yes, sir.
Pritchett.
What did she essentially tell you that night as to what happened?
She told me that she received a phone call from Mason McCarty and her brother that they were stuck out on Jake McCraw Road. She told me that her and Hunter traveled to this location, and she also told me that Mason was reaching for Hunter's gun, and that's when Hunter shot shot Mason, and then they drove away from the residence. And pretty much what Hunter told me that where he sat the gun down, and that was the nature of that first conversation. And she also offered a photo of Hunter's neck.
Okay. Then did you talk to her on another occasion?
Yes, I traveled.
Why did you do that?
Yes, sir. I traveled to Hunter's house, which was 430 Old Louisville Road, and I went back because Caitlin called the GBI office. Normally, I do give out a business card, but she called the GBI office and wanted to offer more information. She let me know that she deleted phone calls and she had deleted text messages, so I conducted a second interview.
Okay. And what did you determine, what were the nature of those phone calls and messages? What did you learn from her about those? What was that all about?
So I just learned, so we conducted the second interview, and once the second interview was finished, she again reached back out to me. Now by this point.
Hold on just a minute. On the
Okay.
second interview,
Yeah.
she told you about some deleted text and deleted phone calls. Did she tell you who those were to and from?
It was deleted messages and calls between her and Mason.
Okay. Did you ever ask her if they were involved romantically?
Yes, I did. I did ask that question.
Okay. Was there some sort of element that led you to believe that they may be involved romantically?
Yes, sir, that is correct.
Okay. And so what was she saying?
Ooh, does that mean Hunter's wife was romantically involved with Mason? Is that what I'm hearing? Because I was talking in chat. I might have missed something.
She had deleted off her phone.
She told me that she deleted messages that would show that she was having the best way I can say is a physical relationship with Mason McCarty. She told me that I would see that in Mason's phone, and she deleted it to hide it from Hunter.
Okay. And did she ever recover those messages? Did she tell you?
She told me that Hunter recovered the text messages on her phone.
Okay. And what did?
Wait a minute, I'm sorry, Your Honor, did not hear the response.
She
Say that, your response again, Mr. Hayes.
Please speak up, speak in the microphone.
Yes, sir. She told me that Hunter recovered the text messages on her cell phone.
Okay. And did she share those text messages with you?
No,
Did you-
no, sir. I corroborated those text messages. Once I knew her phone number, I just corroborated those text messages between Mason's phone. I never saw them because she called me after I left the residence.
Okay. And so did you ask her? You mentioned Mason's phone, the victim. How did you corroborate that?
I downloaded the cell phone using the system, and once I looked in the cell phone, I saw the text messages leading up to Mason's death. I did see the text messages maybe a week or so before his death of Caitlin communicating with Mason. You want me to go into the nature of them?
If you would, please.
So the nature of the text
We got motive, guys. We got motive.
messages were Mason, they were kind of just having normal, casual conversations. And at one point, he asked her for some money. I think specifically $9. And she said, yes, I can send it to you through Cash App, but we're going to have sex. And that was the nature of those conversations. And I also saw the phone calls that began at 6:18 p.m. that showed that Mason was contacting or calling Caitlin several different times leading up to his death, where they had been talking.
Okay. Did she tell you anything about whether or not she was telling Mr. Kersey about whether or not she was communicating with Mason? And I'm talking specifically as to the date of this incident on June the 4th when he was sadly killed.
No, sir, she did not.
Okay. And, well, let's go to, is that the sum and substance of the second interview?
The second and the third, they were all the same.
Okay. And was there ever any confusion as to whether or not she really saw everything as far as what everybody was doing and the gun and all that?
No, sir.
Okay. Did she ever tell you that there was a struggle over the gun, physically, that there was a struggle or anything of that nature?
No, she did not. She just said that he was reaching for it. And when I was leading up to I won't go into the contents of the fourth interview, but that interview took place as well because she contacted us. She knew that Hunter was about to turn himself in, and she wanted to offer more information. And I was dealing with the warrant situation. That's why Eugene Howard went to go speak to her in private.
Was there a big change in what she reported had happened as far as who was the initial aggressor and all that kind of business, and what all happened when, as far as you making a change in your decision as far as what was charged?
Yes, sir, that is correct.
And of course, you don't make the final charge and decision in any case. Ultimately, it's up to the district attorney's office, right?
Yes, sir, that is correct.
Yeah, okay. And as far as what specifically did you base your information off of that you made, what change was there?
So the change that Mason never reached for Hunter's gun at all. Mason was smiling when he jumped on top of that truck. And he just, it was never the way that Hunter explained it was. She was just told to stick to the story until she was separated. This was the first interview where Hunter was nowhere around her, that fourth interview. That was the big change, is that.
So the wife changed her story as this went on. Okay.
He never reached for the gun.
Okay, so let's ask that. The first interview occurred where?
At the sheriff's office.
All right. Where was Hunter in relation to her?
Hunter was still inside the building, but a few rooms down.
Okay. The second interview occurred where?
The second interview occurred at his house, and in the middle of interviewing Caitlin, Hunter walked outside to where I may have even cut the interview or cut it short because he started walking towards the door.
Okay. And the third interview, where did it occur?
The third interview took place at Vidalia Police Department, and Hunter was seated outside in the truck. She rode there with Hunter.
Okay. And then in the fourth interview?
The fourth interview, I believe Eugene spoke to her in Vidalia, and even during this interview, Hunter was texting her, "Where are you?"
And who is Eugene Howard?
Eugene Howard is a special agent with the Georgia Bureau of Investigation.
Okay. Does he have experience?
Yes, a lot more experience than me, more seasoned, and he actually helped train me when I first started with the GBI.
Okay. And do you trust his judgment?
Objection, Your Honor. I mean, I think it's going far astray. If Eugene Howard's here, he can testify as to his own qualifications.
I would like to respond to that, Your Honor.
Matt, sir?
I would like to respond to that, please.
Well,
Without being cut off.
Let's let Mr. Pittman finish. You through?
Yes, Your Honor.
All right, Mr. Pritchett.
Yes, Your Honor. It's been totally a big subject of the cross-examination of Mr. Pittman as to why he would rely on some other agent's information and not go do something himself. And I think it's certainly fertile ground to go into because of the fact that it's been asked. Why didn't you go do it again? Why didn't you go interview yourself? You know. So if he has a trust and judgment of this agent, then I think it's fair for the jury to know that.
Mr. Pittman.
Your Honor, I think that he can say, I trust his agent. I don't think he can go into Eugene Howard's qualifications and stuff because I think they're going to call Eugene Howard as a witness. From what I understand, he testifies to his own qualifications.
I'm going to allow him to testify as to why, what his basis of his reliance on Mr. Howard's statements.
Thank you. You go ahead.
Yes, I did trust Eugene Howard.
Okay. How long did y'all work together?
We worked together for 3.5 years. He transferred to the polygraph unit, but we were still in contact. And even to this day, we just still keep in contact.
A lot of cases together?
Yes, sir, we did.
Okay. And is it common for the lead agent in a case to have other agents to conduct substantive interviews on a case?
Yes, sir, that is correct.
Okay. Are you required to go back and re-interview people?
No.
Because somebody else did it other than you when you're the lead agent?
No, sir, I am not.
Okay. Did you?
I have a weird setup for my YouTube. So obviously when I'm streaming, I'm at a desk with a stupid camera. And that's court vibes. And then I have a different account on my phone where well, that's a lot of music. So it's a lot of music, but some videos. Then I have a different account on my laptop in my bedroom at my bed. So when I'm in bed, it's that way, because the reason why is because YouTube, always constantly likes to give you recommendations on what to watch next. And I don't want my topics blurring. Like at my desk, it's almost pure 100% all court videos. And my account on my phone, that's music. Some videos, but a lot of music. And then it could be anything under the sun. If I'm, trying to go to bed and I throw something on, it could be anything under the sun. And I don't want those suggestions coming up on Court Vibes or coming up on my music. They all serve a different purpose.
What was told, did you review that statement of what had been said in that fourth interview before you made your other decision to change the warrants, to ask for different warrants?
Yes, sir, I did. On top of speaking to Eugene, I listened to the audio myself.
Okay, all right. And, all right. Now, can we approach on one issue?
Yes.
The judge does not remember to turn his microphone on this whole hearing, guys. Just letting you know it's going to happen.
Okay. In cross-examination yesterday, there was some questions raised about whether or not you acted properly in interviewing Samantha Oglesby. Do you recall that?
Yes, sir, I do.
Okay. And do you recall there being a question as to whether or not she told you something about, like a conclusory statement that he was acting in self-defense?
Yes, sir, I remember that question.
Have you subsequently had a chance to review your case file and, having done so, refresh your recollection as to what she actually said to you?
Yes, sir. Yes, sir, I have.
Could you please tell the jury what was said?
The main thing that was different was she did not tell me that specifically that he was acting in self-defense. As I recall, the 911 operator told me that Hunter felt threatened. He said that Mason was being violent towards him and said that Mason reached through the window and was trying to open his door and that he shot Mason McCarty. The way that she told it to me is, I shot Mason McCarty. I'll be at 430 Old Louisville Road, and this is where I'll be waiting on officers. That's essentially what she told me.
Okay. Without getting into the information in the text, because we're going to go there in a minute, and we'll have to call you back. You were asked, though, on cross-examination about text that you observed at the jail.
Yes, sir, that's correct.
That you further to the DA's office in the prosecution in this case?
Yes, sir, that is correct.
Okay. Just so that the jury understands, how did you get access to the information without telling what's in there? How did you get access to the text on the jail iPads or whatever it was you're referring to out there at Dodge County Jail?
I contacted the captain, which was Terry Mullis. I contacted her and asked for permission to set up an account. I think it could have been Paytel maybe, to set up an account to where I could review any emails, any phone calls, any messages, anything that Hunter Kersey would have access to while he was at the Dodge County Jail. Okay. And did you get granted that access? Yes, sir, I did. And did you ultimately access those records? Yes, sir, I did. And did you subsequently ask her to provide you with what you thought, what was relevant as far as communications about this incident? Yes, sir, I did. Okay. And without getting into it, was there a communication about this incident from the Miss Kersey, the defendant's wife, communication between the two of them that was concerning to you? Yes, sir, that's correct. Okay. Now, you didn't put anybody in handcuffs that night? The night of the incident? On the night of June the 4th? No, sir, I did not. When the incident occurred? No, sir, I did not. There was some questions raised about the length of time that Mr. Kersey was there at the sheriff's department before you
do the interview.
Hi, Tina.
You got called in, you said around 7 or 7:30. Tell the jury again what you did from the time you got, where you were coming from, and why it took you so long to get, there was that little bit of delay.
So again, I was on call. I don't expect to get called out, and if I remember correctly, I was exercising, so I had to take a shower, just the normal things that we do. I took a shower. I called Ron while I was there to save time, so I didn't have to speak to him. Once I got here, I had to get myself dressed, and I was driving from Washington County. That's easily at least an hour to an hour and about 5 to 9 minutes to get here. So it takes me a while to get here. I don't live in the county of Montgomery.
And once you got here,
So it would really suck if I did this. Okay, Kathy, play Despacito.
and you got whatever initial briefing you got, you said you got someone on the phone, but who did you talk to first as far as any witnesses to this crime?
Ron Bivens,
And who did you talk to next?
Caitlin Kersey.
And how long did that interview last?
I honestly can't remember, but I think it was under an hour.
Okay. So that accounts for a lot of this time then?
Yes, sir, that is correct.
Was Hunter Curry put back in the jail or anything like that?
No,
Got
sir.
a home cell or anything?
No, sir, he was not.
When you went to talk to him, was he any kind of, was his movement being restricted in any kind of way or any cuffs or anything like that?
No, sir, it was not.
Did he leave there on his own that day?
Yes, sir, he did.
Okay. You were quizzed a lot yesterday about these 911 calls. Did you go through all the 911 calls in this case as part of your investigation case?
Yes, sir, I did.
Did you talk to numerous witnesses?
Yes, sir, I did.
Okay. Do you base your decision on kind of a totality of circumstances? And
Objection, or lead.
Let's not lead the witness.
how do you ultimately come to the decision whether or not to charge somebody?
As you said, the totality of the circumstances.
Okay. There was reference yesterday to Mr. Kersey not having counsel. That's correct, right?
Yes, sir, that is correct.
At the time of the first interview at the jail,
That is correct.
did he ever? Okay, I'll draw that. You went over the rights that we discussed yesterday, didn't you? Correct?
Yes, sir, that is correct.
So did he ever assert his right to his privilege to not talk to you or ask for an attorney?
No, sir, he did not.
Okay. Now, why did you get him to go through this and tell him his own words twice what had happened?
To see if anything would change, or and sometimes it does help people to go through it twice.
Okay. Was he pretty detailed in his statement to you?
Yes, sir, that's correct. He was.
Mr. Pittman has asked about why you didn't ask a bunch more detailed questions. Why didn't you ask more detailed questions? What did you have a lot of details about the case at that point?
No, sir, I did not.
Okay. You were asked a lot about these scientific type evidence, fingerprints, DNA, that type of business. And you're nodding your head if you would answer.
Yes, sir, that is correct.
Okay. Can you tell the jury why a lot of that wasn't sent?
So as I explained yesterday, a lot of the evidence, it just wasn't important. I say our, but the GBI crime lab is backed up enough as it is. And there was a lot of fingerprints, for example, that were taken from the truck. And
He is not qualified to testify as to the backup of the GBI crime lab.
I'm gonna let him testify if he's testifying from his experience about whether or not the crime lab's backed up and everything.
Right.
Objections overruled.
The crime lab is backed up, and I did not find it necessary because that was not a question. Every witness that saw something corroborated that Mason was standing on the truck. So that would be the reason for the fingerprints on the truck not being sent in, or the DNA, because again, it's not a whodunit.
Thank you, Bobby. 33 is not cold. It's not enough to burr. You can't burr over 33 degrees. You can't even freeze anything at 30. I mean, are you talking about Fahrenheit? Because 33 is really hot if you're not. I mean, yeah. I turned my heat off. My heat is off right now. The kids don't know. They're fine.
And I did send certain pieces of evidence to the crime lab. Those that could be processed were processed, that were important to this investigation. And those that could not be processed, the crime lab sent me a letter and explained why they couldn't be processed.
And was there any question as to the identity of the shooter?
No, sir, it was not.
Okay. Was that corroborated by Kate Kersey?
Yes, sir, that is correct.
And I say corroborated what Hunter Kersey told you?
Yes, sir, that is correct.
The, talked earlier about some kind of picture or something over his neck. What does his neck look like? Can you describe to the jury what you saw on Mr. Hurley's neck? As far as what the pictures and everything that just Kate Kersey was showing you?
Similar to what his neck looks like now. I didn't see any bruising. I didn't see any scratches. I didn't see anything.
Okay. What did you mean about that when you were talking to Mr. Pittman about things sounded rehearsed, in Hunter Kersey's state, what were you talking about?
I guess the best way I can explain that is once I asked a question that kind of went off the rails of what he was telling me, he gave a reaction, like an emotional response, such as the question when I asked, what could you have done differently? And he answered the question, but said, I don't feel good about that question. I shouldn't have answered that question, but he still answered it. That's the best way that I can kind of explain that, just sticking to the story.
Okay. You were asked a lot of questions today about an officer using deadly force and such. Is there a reasonableness type situation that goes on as to whether or not somebody should be using deadly force?
Yes, sir, that is correct.
If you were to use force against somebody, would you be put under investigation?
Yes, I would.
And would they be looking to see whether or not you acted reasonably?
Yes, sir, that is correct.
Is there such a thing as excessive force being used by a police officer?
Yes, sir, that is correct.
And also by somebody who's supposed to be working self-defense? Is there such a thing as that?
Yes, sir, that is correct.
That's all I have at this time.
Anything on Reed or Cross?
Yes, sir. Did Ms. Kersey tell you in her statement that she saw Mason McCarty grab Hunter Kersey's gun?
Yes, sir.
Okay, so how is that inconsistent from what Mr. Kersey told you in his statement at the jail?
It's not inconsistent, sir.
Okay? And did she not tell you that she had communicated with Mason McCarty that day, but Hunter Kersey was unaware of those communications?
What's the question, sir?
Did she tell you that Hunter Kersey was unaware of the communications between her and Mr. McCarty?
Yes, sir, she did.
Okay, all right. So I guess what you're trying to do, I guess, is establish a motive. Is that what you're talking about?
Just figure out what happened. You don't always figure out the motive, but just figure out what happened. What do the facts say?
Well, to commit a malice murder, you got to have a motive, don't you?
That's an inaccurate statement of the law, Your Honor.
No.
Mr. Pittman?
You know, there's got to be a plan for there to be malice murder.
Judge,
We're not going there. Rephrase your question, Mr. Pittman.
If Hunter Kersey was not aware of Miss Kersey's relationship or communications with Mason McCarty, then that's not something that would have influenced him in this matter, is it?
I'm kind of confused on your question. I want to answer it the best way I can. Could you ask it again?
Okay. If Hunter Kersey did not know of any relationship or communication with his wife, Miss Kersey, that could not have influenced what he did on June the 4th, 2023.
He downplayed it, but he downplayed what he knew. When I spoke with him, he downplayed what he knew about Caitlin and Mason. He kind of brushed it off as they had their thing going on before me. He said that was before my time, but that let me know that Hunter had knowledge of Mason and Caitlin.
The fact, he had knowledge of the fact that Mason and Caitlin were boyfriend and girlfriend when they were 13 years old, right? Their prior relationship when they were children.
That's speculation, sir. He didn't put an age or time on it.
And you didn't ask about it either, did you?
No, sir, I did not.
But Ms. Kersey did tell you that he did not know, he was unaware of the communication between the two. And isn't that correct?
Yes, sir.
Okay. All right. So if you don't ask him any details about his knowledge of when they dated whenever they were children, and she tells you that he's unaware of any relationship with them or any communication between them, then how could he know about it?
I don't think it's important.
Pardon?
I don't think it's important, sir.
You don't think it's important?
No.
Then why did you even talk about it then? You the one that testified to it a minute ago. That you testified that there was communication between them. You did.
Yes, sir, I did. But their relationship when they were 12 and 13, that's not important.
You testified that there was communication that said that there was a relationship between the two.
I did.
All right. And so you testified to it, but now you're telling us that that's unimportant.
I think it will be best explained. For me to answer that question, I'll have to go into details about what Special Agent Howard learned from his interview.
Cannot go into details.
Yeah, I know.
Pittman, I'll be the one who instructs the witnesses as to what they can and can't go into. Your obligation is to ask questions.
That's true. Your Honor,
Ask your
if
question.
you don't mind, if you would direct him not to go into any details about what Special Agent Howard told him.
Please don't do so, sir.
Yes, Your Honor.
As far as you knew, at this time, according to Mr. Kersey and Ms. Kersey, that Hunter Kersey was not aware of any relationship or communication between her and Mason McCarty.
You are correct.
Okay. Now, I think you said that she did not testify that Mason McCarty, or did not give you a statement that Mason McCarty grabbed Hunter's gun. Is that what you said?
Yes, sir. She told me that the first 3 times.
She told you what? That he did or didn't?
That Mason did reach for his gun.
Okay, well, maybe I misunderstood your answer. So she told you in the first interview that Mason McCarty did grab Hunter's gun.
Yes, sir.
Okay. She told you in the second interview that Mason McCarty did grab Hunter's gun.
Yes.
I just need to know how many people have Chicago, the Broadway, going through their head nonstop with this freaking murder trial.
Sir, or reach for it, one or the other.
Okay. And then in the third interview, she told you that Mason McCarty grabbed Hunter's gun.
Yes, sir. She was sticking to the story.
And as a matter of fact, you told us that, you know, we can find out whether he did or didn't. She also told you that whenever Mason McCarty, he got to Hunter's truck, he stepped on the side rail and said, "Motherfucker, are you here to pull me out?" Didn't she?
That's what she said, sir. Yes, sir.
And then Hunter said that, "I'm not here for you." Correct?
The first time Hunter said he didn't say anything, and then the second time he said that Mason said something, but he didn't know what he said.
Okay. Who said that?
Hunter did, sir.
I'm talking about Ms. Kersey. Ms. Kersey said that she heard him say that.
She said that, but she changed it to, I heard it, I couldn't hear it. Her story, like I said, like he said earlier, it just kept changing and it kept changing until she got with Eugene.
Until she got with Eugene. Mm-hmm. But she didn't make those substantial changes in her story, did she? It was just, she said that Mason got on the side rail of the truck, okay? And she said that what he said, "Motherfucker, you had to pull me out," right?
Yes,
Can I ask
sir.
an answer, Your Honor?
Okay.
Let's go on to something else. I mean, you know, Mr. Pittman, he's answered it. Don't
And,
really see the need. He didn't vacillate when he answered.
I'm sorry.
He answered it and he didn't vacillate when he answered it. So let's go on to something else.
I'm trying to find out what's inconsistent on these statements, Sean, because they're all,
Well, I understand that,
they're all pretty much.
but to ask the same thing after he's responded, that wasn't inconsistent, is time consuming at best.
And in fact, and just one backward question. She told you that she had deleted messages from Mason, so Hunter wouldn't find out about it, did she?
So he would find out?
That she had deleted messages from Mason so that Hunter would not see them.
Yes, that is correct.
Now, I want to touch on Samantha over.
Hold on, I gotta make sure she doesn't throw up on me. I think she's getting ready.
Because you said you went back and checked your notes and stuff. You didn't bring any notes with you again today, did you?
No, sir, I did not.
Okay, you didn't think that there was any other questions that might come up that you would have to refer to your notes?
If it does, I'll cross that bridge when we get there, but I normally don't have notes in front of me when I testify.
You at least bring them to the courthouse, don't you?
Yes, sir. Yes, sir. They're nearby. They're just not here.
They're near, well, where are they? How about that?
They're on my laptop that's in my car.
Okay.
Yes, sir.
They didn't bring them to the courthouse.
No, sir.
So, are you saying that Miss Oglesby, she testified yesterday and said that Hunter Kersey said that he was defending himself? You're now saying that she did not tell you that?
Yes, sir. That's correct.
When did you talk with her?
I spoke to her the night of the incident when I asked for the 911 recordings. She told me that specific recording was not there, and I immediately started the interview.
Right.
So it was that night at about 11 o'clock.
Did you record this interview? Don't you, especially if there is no recording of these 911 calls, did you record your interview with Miss Oglesby as to what she said?
No, sir, I did not.
Okay. So basically we're relying on your recollection that you couldn't remember yesterday, right?
Yes, sir, that is correct.
Okay. Now, you keep laying off, or let me rephrase that. You keep giving us an explanation of not sending in the evidence to the crime lab because on the DNA, well, first off, they're slow. They're backed up, right?
Yes, sir, that is correct.
And if you don't send it in, you do not know whether the crime lab is going to process it or not, do you?
Not unless I send it in, sir. You're correct. You're correct.
Okay. All right. Isn't it your understanding that murder cases are a priority with the crime lab?
No, sir, I wouldn't say that.
The crime lab manual says it does, doesn't it?
For me to be able to explain, there are different divisions. So one division could handle latent prints, one could handle firearms. When I left GBI, there was maybe 2 or 3 firearms examiners in the entire state. I collected guns, and so I came on 2021. Let's just say I collected a gun then. There were still guns that were pending because they're so backlogged of all the evidence that they're getting at one time. So I'm not going to overload them with stuff that's not important to this case.
And you keep telling us about that. Mm-hmm. But let me ask you this. For you to have evidence processed, you basically, the only thing that you have to do is make a request and send it to the crime lab. Isn't that it?
Yes, sir.
Okay. So if you did not make a request and send it to the crime lab, we do not know whether the crime lab would have processed this evidence or not, do we?
I don't know what you're asking, sir.
That's what my dad passed from.
Listen closely to the question, all right?
Yes, sir.
And answer the question, please. Okay. If you did not make a request and send this evidence to the crime lab, you do not know whether they would have processed this information or not, do you?
No, sir.
Okay. And in fact, you did take evidence of crime lab, didn't you?
Yes, sir.
Yeah, I saw in the evidence log where you took the gun and you took the shell casing to the crime lab.
That is correct. And the holster.
Right. So you're already making a trip to the crime lab to take those items.
Yes, sir. That is correct.
And they processed your request on the gun, didn't they?
Yes, sir. They did.
Okay. And the gun, the only evidence that you requested on that that I see was whether the gun and the shell casing matched.
Yes, sir. That is correct.
Okay. So you didn't request anything else about the gun?
When I submitted it, I gave them a synopsis of what the case, the nature of the case, and from there I turned it over to the firearms examiner.
Okay. The nature of the case, and the only thing that was done was the gun, that shell casing came from the firearm, which was something that was never denied.
Yes, sir. That is correct.
Now, you also requested a contact DNA analysis on the holster that Officer Bullard took into evidence that he said that he handled them with rubber gloves and everything else. But you requested a contact DNA on that, didn't you?
Yes, sir. I did.
And you got a response back from the crime lab, did you?
Yes, sir. That is correct.
And I'll show you this defendant's exhibit 58.
No objection.
That is the response from the crime lab.
Wait a minute now, are we admitting 58?
Y'all can get it here.
And there's no objection?
That's correct, Your Honor. No
I just
objection.
admit it without objection. Witness can testify to it.
Now, that document says that they don't normally do contact DNA unless there's special circumstances, and they sent it back and said that you may want to resubmit it, may return for submitting agency, correct?
If he could just explain what it says in the document should speak for itself. That's there, Your Honor, and that's the best evidence.
I agree with that. The document's in evidence.
Likewise,
Well, would we allow them then to answer the question and let them read off the document as to what was said instead of the counsel's characterization of it, which is, I would submit to the court, not a fair characterization of what's actually said in this document.
I think the document's in the record, so the document speaks for itself.
Well, then we
Now,
could be,
Mr. Pritchett, if you don't stop talking over me.
yes, Your Honor, you paused a lot and I didn't realize you weren't finished, Your Honor. I apologize.
If Mr. Pittman wants to draw the witness's attention to a certain portion of the document or wants to question the witness's interpretation of the document, I'm going to allow it. But just to have him read what something says, et cetera, the document's in the record. Do we understand each other? Mr. Pritchett?
I do, Your Honor, but I do believe it would be appropriate for it to be published to the jury at this point because of continued witness rule type issues, and I want it to, for them to see it in the courtroom and not, if it's never going to go back to them, they're never going to see it. They need to see it now or it'd be read to them.
Mr. Pritchett, whether Mr. Pittman wants it published that's his right. It's not your exhibit.
Well, as long as I'm not going to be restricted from
Good job.
reading it out
Judge.
in closing, if that's going to be an issue, because it is in evidence.
It is in evidence.
Yes.
And there's
Okay.
nobody has, nobody has said that you're restricted in any form or fashion. You're jumping to conclusions.
I'm just not trying to hide anything wrong, but I'd rather than
You're
just hear.
jumping to
Yes.
conclusions. You can have a seat, Mr.
I am,
Pritchett.
yes, sir.
Go ahead, Mr. Pittman.
Thank you. Mr. Howard, now this is the report or lack of a report that you received from the GPI crime lab, correct?
Yes, sir, that is correct.
And basically the doctor says we can't do the contact DNA, you can resubmit it and explain why you need it, right?
It says it will be returned to the submitting agency for further questions to contact them.
Should additional information become available, please contact the forensic biology management team it gives the website to discuss testing, correct?
Yes, sir, that is correct.
Likewise, whenever they sent you that, they also sent you Defendant's Exhibit number 59, didn't they?
Yes, sir, that is correct.
Okay. I would tender 59, Your Honor.
Any objection?
If he can lay a foundation as having knowledge of this document, then.
So you have you have an
It
objection?
needs, the proper foundation needs to be laid, yes, Your
All
Honor.
right.
This is a document that's prepared by somebody named Cleveland L. Miles, Deputy Director.
Mr. Pittman?
Your Honor, he just testified that whenever he received this test report back, or lack of test report, that he also received this document with it from the crime lab.
Well, the way to do it is, Agent Hayes, do you recognize 59?
Yes, sir, I do.
And is that something you received?
Yes, sir, it is.
All right, so a foundation's been laid. Any objection now, Mr. Pritchett?
No, Your Honor.
All right. Very simple, guys. Let's go on.
Thank you. Now, this document tells you that you can submit contact DNA requests with the crime lab, but you've got to provide an explanation of why you want it, and and it limits the number that you can do, and on a
He's getting into compound questions again, Your Honor.
One question at a time, Mr. Pittman.
this document says that you can resubmit DNA samples, doesn't it? The contact DNA.
Yes, sir.
Okay. And it also says that you have to explain why you want it, correct?
Yes, sir, that is correct.
And it also says that there's a limit to the number of DNA samples that you can submit on a homicide and non-homicide cases.
Russell, have you seen Mr. Kelly? He's pro se. It's a throuple case. I've had it on here. I've had 5 different dockets full of Mr. Kelly and Mr. Crawford. Now, with the mason jars and the custody and the throuple and the craziness, every single one of this judge's decisions for Mr. Kelly has gone to appeal.
Is that correct?
Yes, sir, that's correct. Yes, sir, that is correct.
And that limit in this case is a single alleged perpetrator. It says 8 samples.
I think someone from the crime lab will have to answer that question, sir. This came from the crime lab. It's just your interpretation of it. I can't say that's what it is, because I did have a follow-up conversation with the lab after this.
You've got that document in front of you, right?
Mm-hmm. Yes, sir.
Okay. Does that say that the operational practices is that on homicides, non-homicides, aggravated assault, this goes on battery, kidnapping, it says if there is a single victim and a single perpetrator, a limit of 8 samples for DNA analysis. Is that correct?
I see that, but I don't know the interpretation behind it, because I had a follow-up conversation with the crime lab
I mean,
that had nothing to do with this.
well then, if you had a follow-up conversation, did you make a record of that? Did you record that? You keep talking about these conversations that you have with other people that you never record or make any record of.
He's arguing at this point. He needs to ask a question.
I agree, Mr. Pittman, just ask quick.
I agree. But the document says that you can submit 8 samples, correct? Is that
Yes.
correct?
Limit of 8 samples for DNA analysis.
Okay.
Yes, sir.
And if you need to submit the DNA comparison,
Yes, sir, that's correct.
and that means like DNA samples from the people that was involved, the alleged victim, the defendant.
No, you're missing. I think you're misinterpreting what they're saying, and I'm pretty sure it's documented. This is documented.
You don't. Okay.
I know this is in my case file. I don't, but I know I talked to them and I recorded it.
I'm not asking what you.
Let's don't get argumentative. Let's ask a question. You respond, Mr. Hayes, and then Mr. Pittman, once he's through, you ask another question.
Now,
The court is getting,
Your Honor, at
Little-
this time, excuse me.
we're gonna do it properly.
Your Honor, at this time, I would ask to publish states of defendant's exhibit 58 and 59 to the jury.
All right, they're admitted. Any objection? Mr.
No objection.
All right, you can post.
It worked out real well for OJ when his lawyers did that.
In short, Mr. Haynes, it was your decision not to send these to the crime lab.
What are these?
The DNA, okay. You're aware that not only was there the contact DNA that you requested on the holster that you could have resubmitted, but you,
I will give a tiny spoiler that the word contempt does come out of the judge's mouth nearer to the end. I'm not saying somebody got contempt. I'm saying it is discussed.
could have sent 7 other DNA samples as well in this case.
You're misunderstanding what that paper says.
The thing speaks for itself. It says that you can.
It says that you have a limit of 8, but that has absolutely nothing to do with this case. There's an explanation in my case file of why they wouldn't process that holster, because I sent a follow-up email to them.
You need to look at this document again.
It's in the case file. That has I'm really unaware of. I'm
Testified
unsure
as to what
why they sent me that.
document, the verbiage of the document is, Mr. Pittman, and now he was trying to give an explanation of his understanding of it, and the court's gonna allow that. Go ahead, Mr. Hayes.
So when I sent the holster in, they told me and they explained why, and I documented it, that they would not process it for contact. They did latent prints, which Mason's prints were not found on that holster, but they would not do contact DNA, and they explained why, and it's in the case file. And I sent a follow-up email pretty much begging them to go ahead and do it, because I did feel like it was important. Like what I said earlier, I sent what I sent to the crime lab of what I felt like was important. But that's on the lab, because once they had it, if they were going to process it, which they've done in the past, they would have asked me, hey, can you submit this or can you add this? Because I always go into details about why I'm submitting what pieces of evidence.
Okay. All right. That's regarding the contact DNA request on the holster. And I think that these 2 documents explain all of that, okay? Now, why, in this document, number 59, it says that you can submit up to 8 DNA samples for analysis, does it not?
That's all been asked and answered now about
Well,
a dozen
The
times. I
document
believe.
speaks for itself. Now, if he's got a different interpretation of it, he can speak to it. Other than that, Mr. Pittman, I think we need to go on.
okay. Last question on the DNA. Okay. Wait, no. All right. You did not try to send any of these. I understand there were 16 other DNA samples, 8 boxes, 2 samples a box.
No, sir, I did not.
Okay, all right. Now, you do not know whether the crime lab would process any of those or not, do you?
Been asked and answered also, Your Honor.
Let him answer.
It's not a whodunit, sir.
Pardon?
It's not a whodunit. I've submitted, in the past, I've submitted other DNA samples if I didn't know who or what was going on, but that's not a question in this case.
That's not the only question that there is. Not only do you have to prove somebody who done it, but you also have to prove the circumstances, and you have to disprove any defenses, don't you, Detective?
Sending Mason's DNA, I sent it the way that I sent it, and it's almost like in the blind to see what they could tell me from what they could see on the holster, but I didn't get any feedback back. We know Mason's DNA was on that truck, but there was no need to send it to the crime lab.
According to the Ms. Cooley that did the search warrant on the truck, she said that she took DNA samples from outside the truck. She also took DNA samples from inside the truck, from the headboard above, on top of the truck, inside on that, all places inside the vehicle. Now, there is that not your understanding? I mean, you've got the case report, you've been reviewed.
What are you asking? You said a lot, but what are you asking? I can't say what she testified to because I wasn't in here.
He
According to
understands
your
everything in the
report,
world.
she took 16 DNA samples, all right? That's true, correct?
If she said that's what she did, that's what she did.
And according to the report, she took them from the interior and exterior of the vehicle, did she?
Yes, sir. Yes, sir.
Would you dispute the fact yesterday that she would have testified that she took DNA samples from the exterior on the thing, from the whole bar?
Oh, for crying out loud. Sir, stop. Move on. Sherlock Holmes would have already proven that the judge really did it.
From the top of the interior of the truck, steering wheel, all of those places. Do you dispute that?
Judge, he can't speak to what she testified to.
Yeah. Mr. Pittman. Objection sustained.
Well, that leaves our whole chat out, Brent.
Did you discuss these DNA samples with Ms. Cooley that executed this search warrant?
I feel like I was there.
Pardon?
I feel like I was in the area or would have communicated with her because I want to say I got the search warrant.
You got the search warrant. She executed the search warrant, searched the truck. Did you talk with her about what she done?
Yes, sir, I did.
Okay. Did you talk with her about 16 DNA samples?
Again, I can't say what she testified to, sir.
I ain't asking you what she testified to. I'm asking you if you talked to her.
If I did, I don't recall, sir. I can't recall that conversation. It was 3 years ago.
Okay. So you chose not to send off 60 DNA samples without
Didn't
knowing
ask
where
and
they come
answer.
from? Okay.
Got nothing to do with the case.
And none of the fingerprints.
I did send off, which was important. Again, grabbing the door, that's not grabbing. I feel like the holster, that's where I focused at because that's where the gun was. I sent off the latent prints and they said they didn't find Mason's prints on that holster.
The DNA, the holster that you did not resubmit with the DNA sample.
They weren't going to process that holster, sir.
You don't know that. You didn't send it back.
It's in the case file.
It's his understanding that they weren't going to process it, Mr. Pittman. He said that several
I understand
times.
that. He's saying that, Your Honor. I
No,
don't
sir, we're not
know.
having a debate. Ask another question or your cross-examination is completed.
Today in court, do you have anything from the crime lab that, where you talked to them and said that you wanted to send this back and they refused it?
No, sir, I do not.
Now, with regards to Mr. Kersey's neck and stuff that night, you did not take any pictures, did you?
No, Caitlin provided a photo, sir.
Okay. And you do not know what the quality of that photograph was, do you?
I was able to see it clearly, sir.
Pardon?
I was able to see it clearly.
Did you go back and examine it, compare it? Why didn't you take your own photographs? You were investigating.
I did the day after, sir. There was no need for me to take a photo that night. I followed up afterwards. It's the reason she took that photo. They believed that it would show me something, and I didn't see anything, sir.
You two went back and rephotographed it, correct?
I'm pretty sure I looked at his neck when I interviewed him as well.
Now, whenever Mr. Kersey was taken to the sheriff's office, you instructed them to sequester him from everybody, correct?
Yes, sir.
Okay. To separate him from other witnesses.
Yes, sir, that is correct.
And that was 2.5 hours before you arrived. And whenever you arrived, they had him sitting in a room by himself.
No, I don't think so, Hedwig. I don't think so. I don't think that this lawyer is trying to say that he didn't do the crime. I think the lawyer is trying to put in front of the jury that the police didn't handle the case properly. I think that is where he's going. I think that's what he's trying to do. And that works. When you tell a jury the police messed up in evidence handling and things like that, that works.
Sheriff's office did it.
He was actually sitting with the sheriff, if I believe correct, the former sheriff.
And so you're saying that his story sounded rehearsed, okay? So are you saying that he rehearsed it with the sheriff?
Oh, that's not what I'm saying, sir. It just sounded like he was trying to stick to the story.
Pardon?
It just sounded like he was trying to stick to what he was trying to tell me, and he didn't want to deviate away from that when I started to ask questions like, what would you do differently? It made him feel uncomfortable.
Okay, listen to me. If you tell him the truth, it ain't hard to stick to the same story, is it?
No, sir, it's not.
Okay, all right. And when you ask him what he done different, he said, that's hindsight.
I love the
He said,
police.
"You
I
can't
do.
really say." He
Hard
said,
job.
I wouldn't have went down that road. Yeah, isn't that what he said?
That's what he said, sir.
Okay. How is that making up a story?
He knew not to go down that road.
Pardon?
He knew not to go down that road, sir.
You're going to have to speak into the microphone. I can't hear you.
My investigation showed that he should have known not to go down that dirt road.
Okay. He should have known not to go down that dirt road to pull his brother-in-law out.
Yes, sir, that is correct.
Your investigation showed that he didn't have any knowledge of any communications between him, Mason McCarty and Caitlin Kersey. Isn't that what it showed?
No telecommunication, but there was a conversation in that truck to where he should have known not to go down that dirt road.
She told you in her statement, whenever all of you were doing this investigation, that he did not know that Mason McCarty was down there.
Yes, sir, that is what she told me.
Okay, all right. So, on June 4th, how would you have even had the slightest inkling that he shouldn't have gone down that road because the purpose he went down that road for was to pull his brother-in-law out?
I didn't have that information. I didn't get the information that I'm referring to until June 22nd, sir.
Pardon?
Until June the 22nd.
And that's not information that you had in any of the three statements that you had previously, and then it changed on June the 22nd, correct?
Yes, sir.
Okay, all right. So you're not basing your opinion of him making up a story or rehearsing it on anything that you knew on June the 4th?
No, sir.
Okay, all right. Now, you talked to the witness 3 times, fairly consistent. Okay.
Now-
Is that true?
Now, Brad, come on. I would never talk about something other than court during a live stream. That's just rude to people who come here to look for court.
Yes, sir. That is correct.
During that period of time, did this witness tell you about receiving threats from the victim's family if she did not change her story?
Repeat that one more time.
During the first 3 interviews, did not this witness tell you that she was receiving threats from the victim's family?
Yes, sir. She did mention that after, I think, the second or third interview.
And that was reasons that she was given, the pressure that she was under whenever she talked with you in the third statement, correct?
I'm kind of confused on what you're asking, sir. I apologize.
Bren doesn't have a disrespectful bone in his body.
Did she not tell you, whenever she spoke with you on June the 7th, that she was receiving threats from the victim's family if she did not change her story?
She said that, but I wasn't able to corroborate it. If I believe I'm correct, that first interview, she actually told me that she spoke with Mason's mother. And I asked, how was that conversation? Because it kind of caught me off guard. And I asked, how was that conversation? And she said that it was a positive conversation because she cared about Mason.
With Mason's mother. But she also told you that she was receiving threats from Mason's father, from his stepmother.
Yes, sir, she did. She did, sir.
Okay. And did she make you aware that there was a divorce proceedings going on?
Between her and Hunter?
Yes.
I think I got that information from the sheriff's office, sir. I don't think I knew too much of it from Caitlin because they were always together up until the end.
Did she tell you that all the stress that she was under, that she had recently had a miscarriage?
I think that was kind of after this case, sir. I do know she was possibly pregnant at this time, but I
It
really
was the
didn't
father, though.
dive too much into that. That's personal.
She did not tell you that she had had a previous miscarriage before this instance and that she was pregnant at this time and then she subsequently, as you know, miscarried.
Yes, sir.
Okay. And then all of a sudden, on June the 22nd, she totally changes her story.
Yes, sir, that is correct.
Had you discussed any of this with Eugene Howard before he went and did the interview?
I gave him a snapshot of it, but just so he could know enough about the information to be able to ask certain questions, but that was about it. He didn't have a big involvement in this case.
So you didn't tell him about all the threats that she was receiving?
I think she mentioned the threats, and that'll come through Eugene, so I won't get into it, but she did clarify that.
Okay. All right.
It was a very detailed interview.
Pardon?
It was a very detailed interview.
Did you make Eugene Howard, the question was, did you make Eugene Howard aware of the threat?
No, sir.
All right. Or aware of any of the other information about the divorce, miscarriages, or anything like that?
I don't believe so. I gave him a snapshot of what I thought was important, but it was like bits of it.
Then don't you think it was incumbent upon you with such a drastic change in the story, knowing that there were threats and all of these other pressures that she was receiving, don't you think it would have been incumbent upon you to inquire as to why she changed her story so dramatically?
She answered that question with Eugene, and it kept him neutral in this because him not having all the information that I had, it just holds the integrity of the case, if that makes sense.
And that's fine. I love that Detective or Officer Howard was neutral on this thing.
Mm-hmm.
And that's my point entirely.
I need Brenda to translate Australian words sometimes.
Not have all of this information about the exterior pressures that she was under. So he doesn't know that she's give all these prior 3 consistent statements, and then all of a sudden there's one that's inconsistent.
The variable of the one that was inconsistent is Hunter was not around for this interview.
Pardon?
Your client, Hunter Kersey, was not around for this interview. That's what changed in this interview.
Was not around for?
He was not around or within earshot of this interview. That's what changed.
He wasn't around or in earshot of the first interview, was he?
Yes, he was right down the hallway, sir.
Okay.
He was in the building.
You had him shut up in a separate room down the hall. You talked with her first.
He was free to leave. He knew he was not under arrest. He could have left at any time.
Okay. Well, let me ask you. Did Hunter Kersey ever come in there whenever you were talking to Caitlin Kersey?
Not the first time, but the second time he did approach the door, and I think that's important.
The first time I'm asking you about, did he come into the room whenever you were interviewing Caitlin Kersey?
No, sir, he did not.
Door shut?
Yes, sir, it was.
Okay. So there's no way that Hunter Kersey, he was with the sheriff, so there's no way that Hunter Kersey could have been an influence on that statement, was he?
No, sir, it was not.
Okay. Now, whenever on the second statement, you said Hunter Kersey was there, he was not in the room with you whenever you were taking Caitlin Kersey's statement, was he?
The second interview?
Correct.
I was sitting in my GBI issue vehicle parked in the yard. She was in the passenger seat, and I was in the driver's seat.
Okay. He wasn't in the vehicle with you, was he?
No, sir, he was not.
Okay, so he wasn't present?
Yeah, he walked outside towards the window, and I want to say that's when I cut the interview and took a photo of his neck. And that's when she contacted me after and said, hey, this is what I did not tell you. And that's why the interviews kept going. If she had stuck to the story like Hunter wanted her to,
Guys,
we would not.
we talked about the fireplace before a couple times, but I gotta tell you, nobody mentioned it yesterday, and I was shocked because every time I play this courtroom, we say the same thing in chat. We all do. Oh, there's a fireplace in this courtroom. Thank you, T. I was waiting for somebody to do it yesterday, and nobody did it.
The first, that would have been it, the first interview.
Like Hunter wanted her to. In the first 3 interviews, she didn't tell you Hunter wanted me to stick to this story, did she? She told you the story.
She was sticking to the story, and that's what I'm sticking to, sir.
So you're telling us that this one interview outweighs all of 3 other interviews that you had where Hunter Kersey wasn't in the room with you, he was down the hall in the company of the sheriff, that she was sitting in your vehicle and the other one at the Vidalia Police Department in the witness room back there?
It's a totality of the circumstances, sir. The content of what she said, how does that corroborate with the evidence that I have in this case? How does this compare to what other witnesses are saying?
And you're relying on the other witnesses, and I assume all the witnesses that said that called 911 and said he grabbed Hunter's gun, Mason grabbed Hunter's gun.
Billy and Jennifer Tidwell. Billy told me, I still don't know what he testified to, but Billy told me, he said, and these are his words, he said, I'm gonna tell you something. That boy never reached inside, he never reached for that gun. And they just said that Hunter was just kept smacking him, and then he gets shot.
So
Monica,
that's what.
I don't know if it's true, but Friend, aren't you in your 40s? Is that what you... I'm trying to remember. I'm desperately trying to remember. But aren't you in your 40s? Is that right?
Billy Tidwell told you, correct?
That's what he told me.
Based this case upon what Billy Tidwell told you.
I based it on a totality of everything. And I look at Billy and Jennifer.
Monica, he's just a baby. He's only 46 years old.
As credible witnesses because they're neutral in this. They're not Team Mason. They're not Team Hunter. They're neutral. They were just riding their four wheels up and down and trying to help somebody who they saw stuck in the mud.
You didn't even take Billy Tidwell's statement, did you?
I took his statement. I did.
Did you record the statement?
I took it and I recorded it.
Okay. How come it wasn't provided in discovery?
I asked the same question, sir. I haven't been around the GBI for a couple of years, but I did interview him and I did record it because I was shocked and I asked questions. Why is this interview not a part of this when I was reviewing my case file?
So we don't have his interview and we don't have his recording, correct?
No, sir, we do not.
Okay. And so we don't know exactly what he said, except that he didn't enter the truck. And then Jennifer Tidwell told you that he didn't enter the truck. She told you that they were 60 to 70 feet away, 50 to 70 feet away.
Yeah, 50 to 70. Right. Yes, sir, that's correct.
And that the four-wheeler was running and that she could not hear what was going on. Isn't that what she told you?
Yes, sir, that's correct.
Okay. So you relying, sounds like, almost exclusively on William Tidwell and Jennifer Tidwell as to what they say happened.
A totality of everything that they said, because for me that changed my perspective of this case, because for now I hear credible witnesses saying Mason never reached for that gun. That's what led me to go to the judge, and as I'm talking to the judge on the voluntary warrants, that's when Agent Howard calls me, and that completely changed everything, and we'll hear that today.
Okay. All right. So that's what they said. So if they were wrong.
Bobby, I have an idea for you. Bobby, listen. With all of your court knowledge from watching all of these court videos, you would be so freaking popular at the women's prison. Just saying, they want visitors. You should try there.
About that, does that change your story or your feelings about this case?
No, sir.
It don't. If the evidence showed that Mason McCarty dived into the truck up here, that wouldn't change your story, your idea of what happened in this case?
No, sir. Not if he wasn't reaching for that gun, sir.
Pardon?
If he was not reaching for the gun, that's a big issue here today.
If he dived in the truck up to here, you don't know what he was reaching for, and the Tidwells do not know what he was reaching for, do you?
But Caitlin does, sir.
Okay. And she told you in her first three statements that he was reaching for the gun.
Yes, sir, she did.
Grabbing the gun. His fingerprints is surely on the gun. You didn't even have the gun checked for fingerprints.
I'm sorry, Your Honor, to keep objecting, but it's just continued compound
I mean,
questions.
Mr. Pittman, we've gone over that so much that even I have called it.
There were other witnesses, correct?
Yes, sir, it was.
It was Austin Peoples. He testified that
Austin Peoples has not testified, Your Honor, and
Do what now?
Austin Peoples has not testified.
Okay, well, let me back up.
And if he's starting to get into, that gets into hearsay type issues.
He has testified previously, Your Honor.
But he hasn't testified in this trial.
If he
Mr.
gave
Pittman.
you a statement that said that
Judge, it's an out-of-court statement that's trying to be admitted through this witness, and I've objected to hearsay, and he continues to try to get into it.
I'll call him back.
That objection sustained, even though you have him on cross-examination, the objection is sustained. How much longer is your cross going to be?
I'm fixing to give him up for redirect. I don't know what.
Well, he's already been on redirect.
Or
case you missed it, he said he's fixing to get him up on redirect. I love when they say that. Sorry.
He's
Sorry,
already
sorry.
been on redirect. And that's why I posed the question, how much longer are you gonna do recross?
I don't anticipate it being much longer.
Much longer is 5 minutes.
15 at the most.
It's 6 minutes and 50 seconds more, is what it is, Judge. I know.
Those are already in.
The neck ones?
Yeah, he put them in. So you give me what, those are, this is 2 days later.
You don't have to pass as a lawyer. You can just talk to the girls. And then when they talk about their case, you can say things that you've learned from all these court videos. They love visitors. I think you should bring cigarettes for their commissary or something like that.
We are at 62.
62.
And I'm 63.
If I was locked up, I would take a visitor. I don't care who it was. You don't know me, that's fine. Come, sit down, let's talk.
30.
Okay, there.
Okay.
So that was 63.
So 62 and 63.
See, I don't show you yours. I don't know that yours was as plain as yours. Okay.
Who made these?
These are copies of exactly what you sent me.
So these are something y'all
I
magnified or something like that?
No, printed them straight up.
That's not-
Yeah,
that's not
they
the picture
play
I got.
games, Bobby. They love games. Hide and seek. Oh my gosh,
if I found
bring
that, that's
chocolate,
fine.
Bobby.
So,
Oh my gosh.
You're
You're gonna have women all over you.
Yep.
All right,
Give me. one
you
back.
got both of them for 62 now.
They're 63 right now.
All right. I don't have objection to 63. I'm not familiar with 62. I don't believe I had to go back.
Well,
and look
let's
at that.
wait till at least he presents them so I can,
Yes, Your Honor.
I'll show you pictures of Stacy's, defendant's 62. And defendant's
It's scary, isn't it, Terry? He's gonna get in trouble.
63. Are those pictures of Hunter Curtis's neck?
Yes, sir, that is correct.
Are those the pictures, which one did you see that night, which one did you see take 2 days later?
well, wait a minute, he's not gonna testify as to the pictures until they're admitted.
You recognize those as pictures of Hunter Curtis's neck, Mr. Singh?
I for sure recognize this one.
How about, that's
And this one is which number, sir?
I don't approve of
All right,
relationships.
63.
Yes, sir. If this one, that one was taken at the house. If this one was taken, it had to be by Caitlin, maybe.
okay. And that's, and she furnished you the picture, correct?
Yes, sir, that is correct.
And you took this one, so you recognize both of those documents?
Fairly, yes, sir.
Y'all right?
Objection.
Not a proper foundation if it was taken by Caitlin. I try to deal with this. I'm gonna, you know what, Your Honor, we move forward. Let's go ahead with it. No objection, Your Honor.
All right, 62 and 63 is admitted without objection.
Those pictures show marks on Hunter Curtis's neck, don't
No, sir, they do not. We can look at it, but they do not, sir. Look at the picture of this after. They don't.
they? Let's let the jury make up their mind. No further questions at this time.
All right, you can step down. You're gonna keep him, aren't you?
Yes, Your Honor, I believe both of us may end up having to possibly recall him. So,
Well,
yes, sir.
he's also the prosecutor in the case, so if you
Yes.
wish for him to remain at counsel table, he can.
Thank you, Your Honor. I appreciate that since my co-counsels handle other business in another court today, so.
All right, it is a little after 12 o'clock. In fact, it's almost 12:05. We're going to take our afternoon lunch break. Ladies and gentlemen of the jury, please be aware and remember the previous instructions that I've given you. If you leave for lunch, please make sure you park back over here on behind where you're sitting, come up the back steps, and let's make sure we don't communicate with anybody. All right, we'll be in recess until 10 minutes after 1. All rise for the jury, please.
Oh my gosh, we can see the jury. Would I date a guy who had a Louis? Yeah, absolutely. Absolutely, yes, I would. 100%. If there's a dog I love, yep.
All right, we'll be in recess until 1:10.
Where you going?
I'm trying to go get Eugene, because he gotta go. Yeah, he did.
We ain't grilled
I know
cheese
he's
and
chomping
french
at
fries
it, you know.
yesterday.
Bring me back.
Get him 110.
Get whatever you want.
So, yeah, I can.
You don't
Loretta,
want- you
the
want-
last guy I dated had this dog named Loretta. Oh my gosh, I miss that dog so much.
You need to tell me.
I would date him again just because I miss
No, I
Loretta
just want
so
you,
much.
I want you to take,
I know, hell,
I'm
if I
like-
slow down, that's. what
I'm like,
doing.
if you wanna go sit down and eat,
No.
take a, you know. No, you're doing I know.
There's the prosecutor lady. She was gone all day. She just got back. I just saw her at the end. She was in another courtroom. Alrighty. That's what we got for today. Thank you so much for coming out. I really, really appreciate it. Today's Friday. I will see you tomorrow morning, Saturday morning. I hope you guys have a great Friday. I hope you stay warm and behave. Thanks, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them. it's a guaranteed good time.